Good evening, everybody. This is Omar Serrato with the Tilted Lawyer Podcast, and we are here to break down the motion to dismiss. Ryan Reynolds and his team of legal assassins have decided to file their own motion to dismiss. What is the chances that they're actually going to get the case dismissed? Slim to none. I don't think that there's any chance personally that Reynolds' causes of action are going to get dismissed for any reason. Well, there might be. I'll tell you what they're arguing, and I'll tell you how I would attack it, and I'll tell you kind of how Baldoni's team is going to attack it when they file their opposition to the motion to dismiss. But for right now, essentially what they're arguing is that defamation claims are fatally flawed. The civil extortion claims are baseless. The business interference claims lack merit, although it's kind of a weak. I mean, if the standard for dismissing a claim is that they are more likely to proceed or succeed on their merits, and that there's no triable issues of facts that a reasonable jury could find in favor of the other side, then I don't see how there aren't at the very least triable issues in this case. I mean, the allegations are pretty severe. That Reynolds, for whatever reason, had a hard-on for Justin Baldoni. And why? I don't know, because he asked his wife how much she weighed because they had like a kissing scene that in his eyes got out of hand because he was jealous of Justin. Who the F knows why? I just know that his behavior towards Justin from the outset, based on the pleadings, was, well, let's just say it was less than cordial. And then the maneuverings during post-production of the film and some of the other things that happened, I can't see how you can make an argument that there are not at the very least triable issues in this case that are going to lead a judge to deny this motion. Do they make compelling arguments? Is it well written? Yeah, it's well written. But that's not the standard, is it? So, before we get into all that, I should probably run the intro because, well, we might as well regroup and log in because it's going to be a good hour or so of legal analysis. Let's get started.
Whatever you might be going through and wherever you might be, this is Omar Serrato with the Tilted Lawyer Podcast. I'm here to take your mind off of things. Yes, I'm an attorney. No, I'm not giving you legal advice. We're going to sit and talk like people, as these are the candid thoughts of one practicing attorney, and it's after hours. So have a seat. Feel free to have a drink and join me. Let's get started.
All right, so here's how we're going to attack this. First, I'm going to tell you about what they are essentially arguing. Just a synopsis. What are they arguing in this motion? And what is this nonsense about? Then we're going to skim through the motion for shits and giggles. You guys like when I do that. And then I'm going to tell you exactly how Baldoni's team is going to attack all of this. So this is the defamation claim against Reynolds. Wayfarer's case is alleging that Reynolds defamed Justin by calling him a sexual predator in private conversations with an agent and a Hollywood executive. That's really important because agents are directly tied to Hollywood execs who are directly tied to business opportunities in Hollywood. And to the extent that you are labeling somebody and going out of your way to call them a sexual predator, that has certain connotations. Think about 1950s America. Let's go all the way back to the days of Desilu Productions. The I Love Lucy show. The I Love Lucy show, that was the first, I don't know if it was global, but it was certainly the biggest television show really for like 30, 40 years. I mean, when it was in syndication from 1950 until 1960 or something like that, Desi Arnaz forms a production team and his wife, Lucille Ball, and they engage in this show. It's called I Love Lucy. And Lucille Ball, I don't want to say she was a failed starlet, in 1940s Hollywood. She had a radio show at some point. She found her acting chops through comedy. She was a brilliant physical comedic artist, and she gained a lot of notoriety from the show called I Love Lucy. Well, come to find out that somebody threw out the possibility that she just might be a communist. And oh, it was such a big deal back then to be labeled that. They might as well have called you a Nazi. If it got out in Hollywood that you were a commie or a communist, then not only were you going to be blackballed in Hollywood, but you were going to be blackballed in life. I mean, in the United States, you were going to be a pariah, a social pariah, kicked to the curb to whatever your devices, I guess, were available, which would have been none. It was such a derogatory name at the time that you couldn't just throw out the name commie or communist without a good faith belief or some kind of plausible belief that this person that you just called that was tied to the Communist Party. Why was that a thing? You're going to have to read up on that yourself. I don't got time to get into it. But when you call somebody a sexual predator, what does that mean to you? What does that mean to you specifically? I were to call your dad a sexual predator. I were to call your brother, your son, your mother, wife, husband, a sexual predator. That is a person that preys on innocents for sexual malfeasance, for sexual nefarious reasons, be it violence, be it lewd, be it lascivious. It's something terrible. That's what we understand that term to be. And there's not really much wiggle room there. There's not like a cartoon character sexual predator. You think of the cartoon sexual predators, you think about the Betty Boop cartoons, where, look, I'm not the one to gauge culture wars or anything like that, but in the 1920s, in the 1930s, early 1930s, if you go back and look at some of those Betty Boop cartoons, they had these cartoon characters that were actually sexual predators that were going in and sexually assaulting Betty Boop. If you don't believe me, just Google it. I promise you, you will find what I'm talking about. But even in that cartoonish state, it was still understood that it was this predator, negative person, somebody to be weary of, somebody that was a danger to women or children or men for that matter. And it has certain connotations. You don't just get to say, in my opinion, you are a sexual predator, and just get like, in my opinion, you are a Nazi. I know that people throw around that term all the time. I know that. I get it. And the reason why people throw around terms like that and, with no regard for what they're saying is because there's a lot of stupid people in the world, truth be told. On average, people are dumb. And they take words like Nazi and communist and sexual predator and whatever, and they throw it around so that it loses all of its meaning. Or they try it. It doesn't actually, but they think that it does. It does when they say it. But when you start throwing those words against actual people that have an effect or can have the ability to impact people's lives with whom the derogatory term is optioned for, then that's where you start getting into this defamation case. Now, Reynolds is saying that it is Reynolds' opinion that he's a sexual predator, and opinion is protected speech under the First Amendment. But the claim from Wayfarer was that the statements were specifically designed to damage Justin's reputation and had directly caused him to lose business opportunities. His reputation was built as this pillar of women's rights, this champion of women's rights. He was making this movie specifically with domestic violence advocacy in mind. And Lively had probably the notion that what's the most damaging thing you could say about this guy? That he's a sexual predator. Because when's the last time we saw, the squeaky clean image, America's dad type, all of a sudden turns bad into like this serial rapist? Oh, well, that was Bill Cosby back in the 80s. I mean, the guy was selling Jell-O pudding pops on nationally televised commercials. He was routinely referred to as America's dad. He was routinely speaking down to young comics that had come after him because of jealousy or because he wanted to impose his stature in the community. Who the F knows? Turns out, like in 2004, 2005, you couldn't really keep a secret for much longer. The extensive levels of grape that man had committed against various unsuspecting women in the industry. And what do we label that guy? A freaking sexual predator. And so Justin Baldoni, it wouldn't be a stretch to the general public that a guy squeaky clean could all of a sudden, you lift under the layers and you see rot, you see evil, you see a propensity for sexual malfeasance, you see a propensity for sexual predation. And that is the heart of the Wayfarer arguments against Reynolds. Now, Reynolds is going to say, oh, it's protected First Amendment speech, whatever. Calling somebody a predator is not a verifiable fact. Actually, it is. Actually, there are some statutes that specifically refer to the perpetrators of certain crimes as predator. It's in the statutory language. And so you don't get to just say that. But because they're claiming that predator, you can't prove that somebody's a predator if it's being meant as opinion. Therefore, it cannot form the basis of a defamation lawsuit. Reynolds alleges a lack of specific allegations. He claims that the lawsuit does not quote Reynolds verbatim or provide specific dates, times, context for these alleged statements. And I would argue that it doesn't effing have to, because we're in the process of discovery. And correct me if I'm wrong, but the pleadings that were filed in this case were not a verified complaint. You know what that means? It means that we get to fill in the gaps as we conduct discovery, as more and more people are deposed. And when we have a more fully formed idea of the specific incidences of this case, then we can start filling in the who, what, when, where, how, and what specifically. Right now, what we have is allegations and this idea that Lively and Reynolds together, and perhaps their PR teams, were up to no good. And whether or not this case gets dismissed is going to depend on whether or not the judge thinks that it is a triable issue, that it's at least up for some debate, whether or not Reynolds engaged in a conspiracy to try to smear the good name of Justin Baldoni. That's going to be the heart of those claims anyway. And then he goes on to say there's no actual harm proven, again, and that's going to be an issue for trial. Damages, you have to prove them at trial. But he says that Wayfarer has failed to show that Baldoni suffered measurable financial or reputational damage directly tied to Reynolds' statements. Sometimes damages are not measurable. Sometimes damages are speculative. Like, what would have happened to Bill Cosby's legacy had he never been accused of what he was accused with? He would probably still be on the pantheon of famous American comedians, on the Mount Rushmore of famous comedians of the 20th century that paved the way for the likes of Dave Chappelle, Bill Burr, and all of the famous comedians today. We would still look at him with great, tremendous adulation. He would still be in the Hall of Fame of comedians, and he would be celebrated. Instead, he's out of prison because of a loophole. But he's going to die a very sad and lonely man. And when we talk about him, there's always going to be an asterisk next to his name. And that kind of damage you can't measure. That kind of damage is speculative. And those kinds of speculations are allowed to be argued at trial. So there's that. What else is he arguing? He's talking about the civil extortion claim. Wayfarer claims that Reynolds engaged in civil extortion by pressuring Justin for a public apology in exchange for avoiding further negative publicity. And that would have been around the time, post-production, give up these credits, issue an apology for all these things that happened. Otherwise, we're going to let everybody know what kind of sexual predator that you really are. Reynolds is saying there was no demand for money or property. But what does an apology really mean in the context of Hollywood? It's an admission of guilt. It gives power to the person that was apologized to. Now all of a sudden they become the victim. And what is being a victim worth in Hollywood nowadays? Not just a victim, but a verifiable victim. That could be worth hundreds of millions of dollars. Speculative. It wasn't the money. You're not gonna write a check for that. They wanted the image, is what Wayfarer is gonna argue. They wanted the image of a verifiable victim that, gosh, it took all of the prayers and well wishes of all of our fans to get through this obscene behavior that we had to endure for months at the hands of Justin Baldoni. What is that worth in the press? That's how Netflix documentaries get made. That's how you put notches on your belt. That's how you continue to build a legacy. That's the kind of stuff that they build perhaps movies off of. So it's kind of an asinine argument that, well, we didn't demand money or property. Like hell they didn't. Like hell they didn't. They go on to say that a request for an apology does not meet the legal definition. Bullshit, it doesn't. And I'll explain why later. They say there's no unlawful threats made. Reynolds was simply expressing an opinion, which is legally protected speech. I mean, fair game. Look, they're going to have to prove. I'm not saying that it's a slam dunk cause of action, because it isn't. Because they're going to have to say, look, they were asking for an apology. Now we're going to have to turn that request for an apology into an extortionary event. That's a really tall task. And so on those grounds, it's true that they're going to have a hard time proving that to a jury. But it doesn't change the fact that it is a tribal issue. I'm not sure if Reynolds, on the strength of what they're arguing, is going to be able to prove to Judge Liman that they are more likely to proceed on the merits on the basis of the civil extortion claim, just because of these definitional differences. There's nuance there. And Judge Liman, what I know about him, just reading his legal opinions, is he's no dummy. I don't think there's a chance that's going to get dismissed, but you never know. As to the business interference claims lacking merit, they tried to make an argument on this. Wayfarer's claim against that is that Reynolds interfered with Justin's contract with his talent agency, WME, by urging them to drop him after making defamatory statements. And then Reynolds is arguing that, first of all, Wayfarer has not identified a single solitary specific contract provision that was breached. Bullshit. Meaning that claim, their claim, lacks specificity that is required for tortious interference. And if the judge buys that, he's not dismissing the claim. He might force them to amend and add more facts, but he's not dismissing. Reynolds is arguing that there's no wrongful conduct, that even if Reynolds had expressed disdain for Justin, for Baldoni, to the WME, that doesn't constitute illegal interference unless all of these arguments are, they really are unless. Like, what if, okay, maybe not having that conversation outright, but what if you are an influential person in Hollywood such that you have a reputation for making and or breaking the careers of aspiring Hollywood actors and actresses? And for years, and your proclivity for affecting the careers of so many is growing exponentially, then all it would take is one wayward conversation to slide into this slitherous avenue of conspiracy defamation to give a subtle hint that, hey, we're blackballing this, but we're not blackballing, but we're blackballing them. And then that's where you have the tortious interference. Now, that is a triable issue. Do we have enough evidence to support that yet? Of course we don't. It's discovery. But they're asking to dismiss the complaint. So if I'm appear to be too far into Baldoni's camp, there's probably a couple of reasons. I really don't like Ryan Reynolds. He's a bully. I don't like him. I don't like how he treated Baldoni. I could relate to Justin and some of the things that he says, and the way that he's been treating that I've seen so far is bullshit. Now, could that change with further evidence? Of course it can. But all I'm saying is they're the ones filing the motion to dismiss. I am analyzing it on its merits just based off of that. They're talking about, Reynolds is talking about the anti-SLAPP provisions in New York, and those are important. So Reynolds wants attorney fees under New York's anti-SLAPP law, basically stating that the lawsuit is a retaliatory attack on free speech. Every state in the nation has these anti-SLAPP laws, meaning if we find out that you sued this individual in an effort to chill the freedom of speech, which is a constitutionally protected right, then there's going to be consequences and repercussions. That's basically what an anti-SLAPP motion is. If it's granted, Wayfarer could be forced to pay for Reynolds' legal costs, which are probably going to be substantial. Judge Liman specifically has previously awarded anti-SLAPP fees in cases involving weak defamation claims, and we'll talk about that in a little bit. And if Reynolds wins, this is obviously going to have the effect of deterring future lawsuits of defamation in the Hollywood arena that resemble Justin Baldoni's. And what Justin Baldoni is essentially stating is he has the framework for a conspiracy that runs Lively, Reynolds, and their PR departments deep, that spans hundreds of people, that spans hundreds of conversations, and it's going to take some work to ferret all of that out. In the future, if he succeeds, it's just going to mean that if you want to bring a conspiracy-like lawsuit, you better have a smoking gun before you come to court. Don't come with these weak-ass motions and expect anything less than sanctions. Anyway, so that is the gist of the motion. I thought it was well written. I'm going to share it with you. We're going to skim through it a little bit. And then I'm going to tell you I'm going to tell you how I think that Baldoni is going to, is Candace Owens really in the house? Are you guys bullshitting? She ain't in the house. She's not in the house. Bullshit. It's not me scrolling the comments. I don't see no Candace Owens in there. Never mind, folks. What was that about? Let me share my screen with you folks so we can get into this a little bit. I mean, it's not the longest of motions. It's just points and authorities. I'm going to skip some of the preamble stuff. Just make sure that's on my screen before we get too far into this. There we go. All right. Here we go. So this is their introduction. Lively sued Heath, Baldoni, it ends with us, blah, blah, blah stuff. So what does Ryan Reynolds have to do with that? Legally speaking, other than being a supportive spouse who has witnessed firsthand the emotional, reputational, and financial devastation Miss Lively has suffered, nothing in bold italics, nothing, Mr. Reynolds is a defendant in this action for one reason and one reason only, because billionaire plaintiff Steve Sarowitz promised to spend up to $100 million to ruin Miss Lively and Mr. Reynolds. The First Amendment complaint that Sarowitz and his co-plaintiffs filed seeks to fulfill that promise by polluting the court's docket with hundreds of paragraphs of clickbait designed for an audience other than this court, with virtually no bearing on cognizable legal claims. Well, I will grant that the pleadings take a lot of liberties like that. It was one of my earlier criticisms of Baldoni's legal team's writing. There's a lot of legal merit to what they're saying as well. It's a steady mix. The Wayfarer parties have described the First Amendment complaints as their attempts to put all the evidence before the court and the public. That is a damning concession, given the lack of any actual evidence supporting any legal cognizable claim against Mr. Reynolds. The Wayfarer party's so-called receipts include annotated excerpts, many with heavy redactions made by some unidentified persons of emails, text messages, videos, and photographs, such as large colored photographs comparing Mr. Reynolds' long hairstyle. And look, I'm just going to point out that this particular portion of the motion is specifically for PR. And they know that. So this is just colorful language that doesn't mean jack shit. They know full well that those redactions were specifically to protect some of the stuff that was being argued in those motions for protection. They got those attorneys' eyes only provisions granted. So I just had to point it out. At any rate, but the FAC is a pleading. It's not a gossip rag, and these so-called receipts fail to establish the requisite elements of a single one of the many causes of action against Mr. Reynolds, the Wayfarer parties. This entire motion is going to be just a really good example of why I just hate talking to attorneys. You can't trust them. They're all bullshitters. They just talk like this, and they talk really fast, and they talk really confident, and use these emotionally manipulative terms. It's just attorneys in general are some of my least favorite people in the world. But here we are, drenched in this legalese bullshit. So here we go. Further, the entirety of plaintiff's defamation claim appears to be based on 2 times that Mr. And I only say that because, God damn it, I've read all of these pleadings. And there were some that were really poorly written. I'm pointing to Lively's First Amendment complaint. And there were some liberties being taken, but they're on both sides. And they know this. This is entirely a PR-driven motion. They know full well this motion is not going to be granted. They'd be lucky to get one cause of action dropped. More than likely, if anything, I think that they're going to allow for amendment of the complaint. Let me stop going on these rants, or otherwise it's going to take forever. Even if the FAC plausibly alleged that Mr. Reynolds called Mr. Baldoni a predator, while believing the opposite, which it does not, the law establishes that calling someone a predator amounts to constitutionally protected opinion. And the FAC's thin-skinned outrage over a movie character, the satirical woke nice pool, does not even pretend to be tied to any actual legal claims. Instead, it falls into the FAC's general allegation of hurt feelings. But those are the basis for damages sometimes, sir. And it's also tangentially connected to a motive, to a pattern of behavior that lends itself to the greater breadth of their causes of action, doesn't it? Which in reality is nothing more than a desperate effort to advance the same curated bully image that the Wayfarer parties created and disseminated in the retaliation campaign they launched against Miss Lively in August of 24. All the other claims fail for similar reasons. The Wayfarer parties say that Mr. Reynolds extorted them, but failed to allege that he received any money or property. They claim he interfered with a contract without identifying what that contract is, what provisions were allegedly breached, or even which of them were parties to it. They assert $400 million in damages without explaining anything about who suffered what loss and what proportion as a result of these, blah, blah, blah. Bullshit stuff. Bullshit, slap suit, whatever, should be dismissed with prejudice. Gotcha. The reality of that is they know full well why those things are in there. They know full well that they don't have to be, all that detailed with their damages at this early stage of the proceedings. But they're writing for, like I said, it's half of this is, I would say 80% of this is probably PR purposes. If he was just writing for the judge, I just feel like this would be written differently. I would hope it would be written differently. All right. Background. Wayfarer parties have asserted a grab bag of claims against Mr. Reynolds and their FAC, including civil extortion claim, defamation, false light, IICR, IIPE, intentional interference claims, negligent interference, prospective economic advantage, and bullshit. $400 million in damages. Despite its length, the FAC alleges only a few isolated acts by Mr. Reynolds with respect to the defamation claim. But here's the thing. Those are the only instances that they know about. All the other stuff is insinuated to have occurred behind the scenes. And all those other things, they're in the investigative process of ferreting those things out. And by the way, it only takes a single complete published statement to the right person to be guilty of one of these causes of action. So this language, again, is a misnomer. I completely understand why people are angered by this motion. You have to just kind of ignore the bluster and get through it's like 80% bullshit. We're just trying to focus on the legal arguments. I'm going to skip over this. Only 2 allegations in the FAC even generously match that description with respect to statements purportedly published by Mr. Reynolds. Her publicist, Leslie Sloan, went so far as to propagate malicious stories portraying Baldoni as a sexual predator, a term Lively's husband, Ryan Reynolds, also used to describe Baldoni when he called Baldoni's own agent. Baldoni later received word that during the premiere of his movie, Deadpool and Wolverine, Reynolds approached Baldoni's agency, namely an exec at WME, and expressed his deep disdain for Baldoni, suggesting the agency was working with a sexual predator. That's pretty fucking defamatory, if not true, or if it was based on him asking Blake Lively how much she weighed, or a wayward kiss that was carefully choreographed ahead of time. If I'm Judge Liman, I'm kind of reading that saying, yeah, so isn't that enough? What are we doing? Apart from those 2 statements, the totality of the FAC's allegations against Mr. Reynolds are that Mr. Reynolds, 1, demanded that the Wayfarer parties publicly apologized for so-called mistakes during production of the film. 2, was present during a meeting at the apartment that he shares with Miss Lively, at which he praised Miss Lively's version of a scene. I told you I was going to get him in trouble. Version of a scene in Mr. Baldoni's presence, allegedly contributed some writing of his own to the script, admonished Mr. Baldoni for asking about Miss Lively's weight, and demanded that a scene be removed from the film, attended a meeting with Miss Lively to address her allegations of sexual harassment on set, and demanded that Mr. Baldoni apologize for his conduct. Unfollowed Mr. Baldoni on social media and included the nice pool character in Deadpool and Wolverine that the FAC alleges was meant to satirize Mr. Baldoni's persona as a weak or a woke feminist. All right. That's the bullshit. I know, I will admit that that last paragraph was better written than some others. It wasn't bad. What's up, Snow Wonder? What's up, P. Mahone, Kieran, all of you folks? Oh, you made me lose my place. All right, so this is the legal standard. In reviewing a motion to dismiss, this shouldn't be unfamiliar to any of you because we just kind of went through this before. Federal Rule 12b-6. The court accepts all factual allegations as true and draws all reasonable inferences in the plaintiff's favor. However, this requirement is inapplicable to legal conclusions and threadbare recitals of the elements of a cause of action, supported by mere conclusory statements, do not suffice. A complaint must offer more than labels and conclusions or a formulaic recitation of the elements of a cause of action or naked assertions devoid of further factual enhancement in order to survive dismissal. Argument. The claim against Mr. Reynolds the claims against Mr. Reynolds fail under both New York and California law. Why are we talking about California and New York law? Well, because it was in the contracts. While the Wayfarer parties appear to agree with Ms. Lively that California law applies to the allegations in the case that she filed, that does not answer what law applies to the Wayfarer parties' claims against Mr. Reynolds. The choice of law may vary by defendant and also by specific claim, even against the same party. To the extent that there is no conflict between California and New York law with respect to the Wayfarer parties' claims against Mr. Reynolds, the court may simply apply New York law. To the extent there is a conflict, as there may be with respect to the extortion, false light, negligent interference claims, New York law applies to the claims against Mr. Reynolds because New York is the jurisdiction having the greatest interest in those claims given the way of the way the Wayfarer parties pled the claims against him in the FAC, I'm not willing to grant them that concession. If that's the argument, I'm not willing to grant them that. That jurisdiction has the greatest interest. I don't know. I'm not so sure. The FAC's allegations as to Mr. Reynolds focused solely on conduct that occurred in New York while he resided in the States. But there was contracts that were tied into to California. Well, I don't know. I'd have to research that a little bit more. I'd have to look at the specific contracts. I don't know how I feel about that, but my instinct tells me that that's probably arguable. New York's interest analysis focuses on parties' domiciles and the locus of the tort and applies New York law when complaint contains no factual allegations linking conduct with any other state. All right, so whereas here, Mr. Reynolds' alleged torts are conduct regulating rather than loss allocating, the law of the state where the conduct occurred will typically apply. Typically. Further, unlike Miss Lively, Mr. Reynolds was never an employee of Wayfarer Studios, nor did Mr. Reynolds ever have, unlike Miss Lively, any contractual relationship with the Wayfarer parties, and therefore no contractual choice of law provision to apply, as set forth below. However, each of the claims fail under New York and California law, and therefore the FAC should be dismissed with prejudice against Mr. Reynolds. And why they even bring it up? The court should dismiss all of the 6 causes of action as to Reynolds with prejudice. FAC fails to state a claim for defamation. They're going to go about that whole thing about opinion again. Defamation claims fails as a matter of law, fatally deficient, does not identify a single allegedly defamatory statement published by Mr. Reynolds, including either of the predator statements. Moreover, to state a claim for slander, a plaintiff must plead a defamatory statement of fact that is false, published to a third party of and concerning the plaintiff, made with the applicable level of fault on the part of the speaker, either causing special harm or constituting slander per se, not protected by a privilege. Case law. The FAC fails to plead the claim in virtually every respect. I guess they're going to explain it to us. The Wayfarer complaint does not sufficiently identify any defamatory statements. The court should dismiss defamation claims for Reynolds because the FAC does not include allegations specific enough to afford him sufficient notice of the communications complained of to enable him to defend himself. Well, I think they just kind of identified it though, didn't they? The predator stuff. I think that's sufficient identification. And I think they've already lodged defenses to both of those instances. So, and they're not alleging anything else. What else do we got here? As this court has noted, it is only by pleading the substance of the purported communication that a defendant can challenge, and upon a motion, the court can determine the essential elements of a defamation claim under New York law, including whether the statement was false, whether it was capable of defamatory meaning, and whether it was of and concerning the plaintiff. I kind of already answered that question. I mean, the issue is going to be whether or not sexual predator as a derogatory phrase, that is not really in question. That was the phrase. Whether or not that rises to the level of calling somebody a communist, a Nazi, a Nazi sympathizer, whatever. If it rises to that kind of a level in the right context, then I think that it's defamatory enough. I'd imagine that's what the opposition is going to focus on. The First Amendment complaint fails to sufficiently plead the substance of the predator statements, which are the only ones relevant to the defamation claims. It's getting repetitive, isn't it? As to the agent statement, the FAC does not plead what Mr. Reynolds said when he said it, or any of the context surrounding the conversation during which he purportedly uttered the agent statement, stating only that Mr. Reynolds used the term sexual predator to describe Mr. Baldoni during a phone call with Mr. Baldoni's agent. The absence of these details makes it impossible, for example, to determine whether his statement falls within the applicable one-year statute of limitations. But here's the thing, you don't get to say things to people that control your career in private And just because you're unable to know the context of why it happened, or the fact that you know it happened, it's enough, or you should be able to bring a complaint and do the requisite investigation during litigation and fill in the gaps at trial. That's kind of the reason why we have due process laws protected by the Constitution. So I see what they're saying, but it's fallen a little flat for me. It's a little bit disingenuous, but I see what they're trying to do. The sole allegation as to the executive statement provides only slightly more detail, namely that Mr. Reynolds and an unnamed executive at WME had a conversation during a movie premiere about Mr. Reynolds' deep disdain for Baldoni, suggesting the agency was working with a sexual predator. The FAC does not allege what precise term Mr. Reynolds used in this alleged suggestion. The sentence in which he allegedly suggested it, or any information about the context of the conversations other than that one of them was about how much Mr. Reynolds dislikes him for having sexually harassed his wife. Such bare-bones pleadings fail to satisfy Rule 8 and warrant dismissal of a slander claim. Well, that's kind of the point. Bare bones pleading is kind of the key phrase there, isn't it? Because it suggests that fill in, if anything, just fill in the holes. If there's holes you need to fill them in. It suggests to me this isn't getting dismissed. What might happen is Judge Liman orders an amended complaint filling in the gaps. That might happen. I could see that happening. I could see it happen, but not dismissed. All right. The predator statements are not defamatory because they are constitutionally protected opinion. Courts must distinguish between statements of fact, which may be defamatory, and expressions of opinion, which are not defamatory. Again, same argument applies. When you think of sexual predator, I feel like Baldoni's legal team is going to make an attempt to elevate that to akin to the communist Nazi phrase that I was talking about earlier, or similar terms like that. That's really the defense or the opposition to that argument. I'm not going to repeat it for time purposes. The predator statements constitute unactionable opinion because they have no precise meaning. It has a precise meaning. It is capable of being objectively characterized as true or false. You're either guilty of being a predator or you're not. And are merely a general reflection of the speaker's view. Yeah, I've heard that argument already. Use of colorful language such as predator, victimized, face of evil are not actionable in and of themselves. They're citing cases that state those things. The face of evil and victimize is colorful language. That doesn't have the same connotation as a sexual predator, by the way. They're citing this case that had that specific phraseology. The word predator by itself, but when you stick the word sexual predator in front of it, notice he didn't find any cases that specifically said that, because that's a little bit different, isn't it? That's a little bit of an escalation. Wouldn't you agree? Calling someone crazy is a hyperbolic expression of opinion. Agreed. 4-year-olds use that word. 4-year-olds don't use the term sexual predator. Calling someone evil, an animal, shameless is hyperbole, right? While Mr. Baldoni may not appreciate being called a predator, those hurt feelings do not give rise to legal claims because name calling does not reflect a fact but a non-verifiable view. Except in an industry where Harvey Weinstein was like less than 10 years ago and Bill Cosby was like 5 years ago. And Michael Jackson before that, and just name your case. Being a sexual predator in Hollywood is a little bit different. If you're in that specific industry, just start throwing that phrase around to potential future employers. Seems to be the obvious argument. These First Amendment principles ought to be obvious to and even celebrated by a group of litigants who have spent most of this past few months calling Mr. Reynolds and his wife bullies and liars. There's a distinct difference to being called a bully and a liar. That's not the same as being called sexual predators, sexual harassers, sexual assaulters. It's just not. You can't ever, not in this end of the parallel universe, equate that phrase with bullies and liars. You just can't. The FAC fails to plead any facts indicating that Mr. Reynolds' statements could be reasonably understood to have been an assertion of fact, capable of being proven false rather than a pure opinion that is not actionable under the New York laws of New York. While the FAC fails to provide sufficient details, I'll shut up. Predator statements during a phone conversation with Mr. Baldoni's agent and at a movie premiere during a conversation with a WME exec during which Mr. Reynolds was expressing his deep disdain for Mr. Baldoni, which is utterly fatal under the opinion doctrine because it is plainly reflective of Mr. Reynolds' unabashed negative opinion of Mr. Baldoni's character. Now, you preface that. He's kind of setting the context for Friedman's legal team, isn't he? What is the context of this? Of where does sexual predator come from? A guy that has an utter amount of disdain for Justin Baldoni for a multitude of reasons, has motive and opportunity to affect his career by using certain buzzwords towards the right people, and you don't think that that could possibly be slanderous or defamatory? Or tortiously interfering with future business opportunities? Fuck all the way off with this argument. Now, I know that Friedman's team is going to say it a lot more artfully than I just did. I'm just saying that this line of reasoning is bullshit. Mr. Reynolds has a First Amendment right to hold Mr. Baldoni or any man who Mr. Reynolds believes sexually harassed his wife in deep disdain. Show me any evidence that he actually sexually harassed his wife. I know we're not going to be able to, oh yeah, discovering this and that. I'm not even basing this off of prospective evidence. Just give me the worst claim of all of them about what he did to sexually harass her or behave inappropriately. I just haven't seen it yet. Pled on Lively's side or Baldoni's side. I don't, it's not connecting for me. Whenever I think of sexual harassment behavior from Baldoni, my mind draws a blank. I just haven't read about it in this case. Now, maybe there's some great revelation to come in deposition statements from other people accusing him of other things. I just don't see it, man. This is not, to me, and I've said it many times, a case about sexual harassment, which is problematic because when I don't see a viable sexual harassment claim and there is attached in this lawsuit a countersuit specifically for calling a man a sexual predator when it appears scant evidence exists that there is a semblance of at least a per se claim of harassment, it's problematic. It's problematic because you don't have a factual basis for believing that he was a sexual predator, meaning that you knew it wasn't at the very least provably true, and you said it anyway, which means that you knew that it was false, and you said it anyway to great detriment to his financial future. I think they're just kind of making Baldoni's argument for him in this paragraph. I don't know. What do you all think about that? This court should dismiss the defamation claim as to Mr. Reynolds with prejudice because the predator statements are expressions of opinion that deserve. I don't think they're going to dismiss. I'm just going to say that. They got a second point. If the predator statements are not opinion, they are substantially true. What the fuck? Oh. I mean, I guess, right? They're true because he believes his wife, is what he's going to say. The second court has held that whether statements are substantially true is appropriate for resolution in a motion to dismiss because falsity is an element of New York defamation tort, and falsity refers to material not substantially true. The complaint in this case must plead facts that, if proven, would establish that the defendant's statements were not substantially true. A statement is substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. when the truth is so near to the facts as published that fine and shaded distinctions must be drawn and words pressed out of their ordinary usage to sustain a charge of libel, no legal harm has been done. It is not necessary to demonstrate complete accuracy to defeat a charge of libel, and all that is necessary is to demonstrate that the gist or substance we get, they're saying, right? The FAC includes numerous references to conduct that a reasonable observer would well consider predatory. Hit me with it. Hit me with it. In particular, the FAC relies on Mr. Baldoni's books, Boys Will Be Human and Man Enough, and his podcast, Man Enough, even going so far as to declare that anyone who knows Baldoni would have knowledge of the contents of Mr. Baldoni's books. Relying on statements made on Baldoni's podcast and ruling on a motion to dismiss, the court may consider documents possessed by or known by a plaintiff and stuff. Those materials with which anyone who knows about Mr. Baldoni would be familiar include numerous admissions to behavior that could reasonably be described as predatory. So tell me about it. See, Jane, boys will be human and talk on healthy masculinity, saying that I'm sure that I have crossed boundaries and lines in my teens. In my teens. He's a 40-year-old man, you dipshit. Teens and 20s, not even thinking about it simply because of the porn I was consuming. The monstrous nature of this man. The Man Enough podcast, Jamie Camel, changing the narrative, YouTube at 3842. I grew up and I had an addiction to porn. I was introduced to porn at 10 years old, formed these neuro pathways in my brain, and it caused me to see the world very differently. A Life of Greatness, Justin Baldoni, The Power of Being Enough. And for me, it was really tricky because I believe that there's a link between rape culture and porn culture. I'm not calling out the porn industry. I'm calling out my relation to it. But I do believe that especially the porn that young boys are watching is very violent. And because no one ever sits us down and teaches us about consent, we learn it through porn. Is it just me, or does that seem like a guy that recognizes that he used to be at one place and now he's at a much more elevated place through natural evolution of a man? Isn't that kind of the point of him even going into these talking points at all? The Man Enough podcast, Joy DeGroy, Access to Respect. Okay, you, right, as a black man, or you as a woman, have had to put up with a lot of shit from people that look like me or from me your entire life. And again, it could be laundry, or it could be microaggressions for racism or sexism, whatever it is. I've done all of them. I don't understand the propensity for Lively and Reynolds' legal team to continue to highlight Justin Baldoni's open evolution as a guy who used to be something and turned into this other thing, using it as evidence of, so therefore, he should have known better with Lively. Okay, but what did he do? What did he do? Give me any evidence that he actually did something that a reasonable person would find amounted to sexual harassment. I wanted as a man to claim her publicly, as on some level I knew it would make me feel more like a man. In a book that he wrote. While it is unclear what predator means to an average listener, it is quite clear that there is no discernible distinction between the gist of Mr. Reynolds' purported statements and the very behavior to which Mr. Baldoni was repeatedly confessed in public appearances, including that he spent years of his life mistreating women, which he attributes to a lengthy addiction to pornography, as well as openly describing his distorted conception of consent in sexual relationships. Were this case to go to trial, it would be Mr. Baldoni's burden to prove the factual falsity of the supposed allegation that he is a predator, but the law offers no principled basis for a jury to distinguish that label from Mr. Baldoni's descriptions of his own behavior. This paragraph just feels abnormally slimy. Just absolute fucking piece of shit this lawyer is, this writer. Of all the lawyers that have written anything in this case, I like this one the least. I know that is a skill that lawyers have to take the words of the opposition and twist them for your own narratives. But Baldoni has spent years of his life, it seems, being this public person who has been very open about his struggles as a man. Yeah, he talks about stuff about consent, and then they're thinking that that's somehow going to relate to him being a predator, as if he knows full well what we mean by a predator, by the way. He talked about it in terms of consent. So what he's basically alluding to was the fact that Baldoni obviously violated consent in previous relationships. That would be what he's alluding to, right? But this lawsuit is not about Justin Baldoni's youth, about who he was as a child, as a teen, as a young man. It's not about his evolution of a man. It's like he used to be this shitty guy, and then he recognized the error of his ways, and he became this person, because we're dealing with him now in his 40s as this evolved person who has learned all of these lessons, and they have shown no discernible evidence to my eye that will lend itself to him somehow crossing boundaries of consent. And I'm not going to rehash all of the reasons for that. Sexual writers and intimacy coordinators be damned. Not right now. I don't have the time tonight or the patience. This is just a shitty paragraph. Just super, super slimy. Finding substantial truth where in an article called Plaintiff, or what are we talking about in this case? Giussioni versus Hustler Mag. Finding substantial truth where an article claimed plaintiff and adulterer became an average reader, because an average reader would understand that term to include the admitted truth that he was a man who unabashedly committed adultery for 13 of the last 17 years and whose adulterous behavior ended only because his wife ultimately divorced him. Well, that's exactly the same thing, isn't it? It would be perverse to permit Mr. Baldoni to build an entire brand, complete with a podcast, TED Talk, books, off of his confessions of repeatedly mistreating women, only to turn around and sue Mr. Reynolds for $400 million for simply pointing out in private what Mr. Baldoni had bragged about in public, bragged about, or humiliated himself openly and humbly admitted and confessed the transgressions of his youth. And I would venture to guess, in my head, what this guy looks like. He looks like that guy in Pretty Woman, the guy that tried to grape Julia Roberts because she was a prostitute when he got her alone in Richard Gere's hotel room. That's the picture. That's the image of the guy that I imagine is writing this motion right now. Just a complete, utter piece of shit. Now, that is my opinion. So he can fuck right off. We're going to leave off. In light of Mr. Baldoni's own public admissions, of which the court can take judicial notice, the substantial truth doctrine requires dismissal of Mr. Baldoni's defamation claims as to Mr. Reynolds. Oh, boy. I don't like that. The FAC fails to plead special damages. Dismissal of the defamation claim is warranted because the FAC does not allege defamation per se, but nonetheless fails to fully and accurately plead special damages with sufficient particularity to identify actual losses. I'm not going to waste everybody's time with their claim about losses. Just know that they're going to oppose it, and there's going to be reasons. And it's not all that particularly interesting. They're going to say that he didn't prove his damages. Well, is there anything that's worth getting into? As a public figure, Mr. Baldoni must plead facts demonstrating that Mr. Reynolds uttered the predator statements with actual malice. In other words, that Mr. Reynolds, in fact, entertained serious doubts as to the truth of his publication. Well, wouldn't that just be about the serious disdain that he admitted that his client had for Baldoni? Wouldn't that be enough to give motivation for malice? He hated the guy, and he had a motive to get him out of the way so that Lively could profit. Wouldn't that be enough motive and grounds for malice? Seems like it would. The FAC's conclusory assertion that Lively parties knew the statements were false, or had serious doubts about the truth of the statements, is a threadbare recitation of the legal element that is insufficient to sustain the law by the law's heavy burden on defamation plaintiffs. Pleading actual malice buzzwords is simply not enough to nudge a case into discovery. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements are insufficient to support a cause of action, nor do claims of animus like Mr. Reynolds' deep disdain for and rage and wrath directed at Mr. Baldoni sufficiently plead actual malice. I would disagree with him on that one. It would be inconsistent with the FAC to find that Mr. Reynolds uttered the predator statement with actual malice. Indeed, there is not a single plausible allegation from which a jury could conclude that Mr. Reynolds does not believe Mr. Baldoni to be a predator. To the contrary, the FAC alleges that Mr. Reynolds took steps consistent with believing his wife's allegations, including demanding an apology from Mr. Baldoni and mocking Mr. Baldoni's woke, feminist facade and Deadpool and Wolverine, not to mention Mr. Baldoni's own public admissions about his past conduct. The deep disdain that the FAC alleges Mr. Reynolds feels towards Mr. Baldoni's concedes that Mr. Reynolds subjectively believes what he said about Mr. Baldoni and thus defeats a finding of actual malice. If that were the case, then why was Blake Lively so friendly with Justin from the very outset? Why wasn't Ryan Reynolds exclaiming about the sexual predations of Justin Baldoni from the very outset of the movie? That's not somebody that's been aware that Baldoni was a sexual predator for the entirety of knowing him. There was something that happened, and you could speculate what that is. It's not my place to speculate what that is. You could say it was after the no teeth comment text message that Justin was non-responsive to. Started talking about his wife and kids in response to Lively's attempts to flirt with her. Now, I don't know if she was attracted to him. I don't give a shit. I don't. I'm just saying it's not that far-fetched to feel like Ryan Reynolds might have been a little bit jealous of Justin Baldoni. Was some of that perpetrated by Lively? Maybe. I have no fucking idea. I have no idea, and we're not going to know. We'll probably never know. They're going to try to ferret that out through discovery. Are they going to be successful? I don't know, man. All I'm saying is that I feel like Ryan Reynolds had a lot of influence over who Blake Lively participated in films with. And there was no objection to Reynolds, to Baldoni co-starring in this movie with Blake Lively until significantly after the fact and after very specific key moments of the timeline that we know about. So this idea that, by Justin Baldoni's own admission, he was a predator, and Ryan Reynolds always knew that he was a predator, and therefore he thought he was being truthful when he said he was a predator. And all this, nice try. Good effort. Good try. Good effort. I applaud the effort. But that's a tribal. That is going to be a tribal issue for the jury to ferret out. I see what they try to do there. It was a really good try. Really good try. I am not buying it. I don't buy it. I'm not buying it. Look, you could buy it at trial if you want to. The evidence is going to speak for itself. But for purposes of this motion to dismiss, fuck all the way off. It's actually a creative argument. I like it. It's not poorly written. It's well asserted. I see what they try to do. I just know too much about the timeline and specific things that happened in this case for me to think that they're going to just have Judge Liman say, okay, well, I guess that's why he called him a predator, is because he read his books and listened to his podcast the whole time. Fuck off. Judge Liman wasn't born yesterday, neither was I. The predator statements are not of and concerning any Wayfarer plaintiff other than Mr. Baldoni. The predator statements refer solely to Mr. Baldoni and not any of the 6 other Wayfarer parties, to the extent that the FAC intends to assert the defamation claim on behalf of any defendant other than Mr. Baldoni. It requires dismissal because the predator statements are not of and concerning any of them. He might have some merit to that argument, actually. To the extent they're not trying to hold Wayfarer liable for predatory behavior of Justin Baldoni, I guess. There's some merit to that. I like that argument. I would buy that argument a lot better than these other ones. The Wayfarer complaint fails to state a claim of false light. The FAC fails to state a claim of false light as a matter of law. There is no tort of false light invasion privacy under New York, and the court need not engage in any further analysis nor dismiss such a claim. Unless California law applies, which I'm not sure that it doesn't. While California law recognizes claims of false light, dismissal also is required when, as here, the claim for false light invasion of privacy is duplicative of a defamation claim. While the FAC's false light claim suffers from the same fatal attack of specificity, it also fails because it appears to rely entirely on the alleged public disclosure of information on which the defamation claim is based. Finally, even if all of that were not dispositive, the false light claim fails as a matter of law for all the same reasons the defamation claim cannot survive dismissal. Whether applying New York, okay, that was it, huh? That a civil extortion claim against Mr. Reynolds must be dismissed because New York law does not recognize, okay, extortion. I'm not going to go over this. The most of that California state courts have recognized under the heading of civil extortion is a cause of action for the recovery of money obtained by the wrongful threat of criminal or civil prosecution. I've actually litigated a case like that, a securities fraud transaction case. I know a little something about it. Because the cause of action is a form of fraud, it must be pled with particularity under Rule 9b. That's 100% true. The FAC is devoid of any allegations, much less particularized allegations. And that is a problem with the biggest problem that I see with Baldoni's or Wayfarer's pleadings, however you want to phrase it, is that it appears, and they're not exactly alleging a fraudulent scheme, conspiracy type cause of action, but it seems like they're trying to. And they're not really conducting the dots about who was involved and how that all worked. Now, it might be forthcoming that in the course of discovery, we get there and they go to amend the complaint to add that as a cause of action. But this idea that it has to be pled with specificity is 100% true. That's probably why it's not a direct cause of action in the case, because they don't know enough yet to ferret that out. Mr. Reynolds obtained any money. The FAC is devoid of any allegations, much as particularized allegations that Reynolds obtained any money or property from. Again, it's not about the money or property. In Hollywood, it's about the image and the notoriety. They're akin to money or property, or made with any wrongful threat of prosecution, much less knowledge of falsity of the claim. And the same is true using the borrowed elements of criminal extortion. The FAC fails to allege that Mr. Reynolds either obtained any property. Shut up. Intentional interference claims must be dismissed. Why? As an initial matter, each of the tortious interference claims must also be dismissed as duplicative of the defamation claim. New York law considers claims sounding in tort to be defamation claims where those causes of action seek damages. Whether Reynolds' alleged statements to the WME are actionable in light of their claimed effect on Baldoni's reputation must fall. FAC fails to state a claim for IIC with contracts. Existence of a valid contract, okay. To survive a motion to dismiss, plaintiff must specifically plead the existence of a valid contract and must identify what provisions of the contract were breached as a result of the acts of issue. Now, that's going to be an interesting decision for Judge Liman to contend with, because there were contracts and there was like a couple hundred different revisions of the contract by the conduct of the parties. There were contracts that were signed. There were contracts that were not signed. And then they filmed a movie anyway. There was a lot of concessions given to Lively specifically. And so, yeah, we're going to have to know specifically what portion of the contract are we talking about. Because if you claim that, well, Lively broke the contract by doing this and that, well, what do you mean? because it seems to me that you continued production of the movie under her terms. Doesn't that represent a modification of the contract with different terms? Now we have to redefine what the new terms are, kind of. So that's going to be an issue. Furthermore, because a claim of tortious interference requires a showing of breach, contracts that are terminable at will generally cannot provide the basis for such a claim. Generally. Oh, it's the Orange City Choppers case. A plaintiff must also plead a specific allegation to the defendant's knowledge of the contract, including some knowledge of the terms and conditions. The FAC fails each of these requirements. The sole contract alleged in the complaint is a contract between Wayfarer and WME, but the FAC does not allege any details about the contract, including which parties it allegedly bound, what the contract's terms were, or what provisions were allegedly breached. Strikingly, throughout the entire First Amendment complaint, there was not a single allegation that WME breached its contract with any Wayfarer party, much less a description or quotation of a contractual term allegedly breached. And I think part of that is because so many there was written contracts and they weren't all signed. And it's hard to really pin that down because there were so many different modifications. I feel like that's probably the reason why they're even able to argue this. Instead, the Wayfarer parties allege solely that upon information and belief, Ms. Lively and Mr. Reynolds induced WME to cease performing under its contract, but the cessation of performance is not the same thing as a breach of contract, and the Wayfarer parties who have alleged the existence of this contract and are presumably in possession of its full terms have utterly failed, after multiple tries, hundreds of pages, to identify any contractual provisions that they claim WME breached when it allegedly ceased performance. Well, I think that the breach is simply Miss Lively threatens to quit, inducing WME to quit unless things resume, forcing them to bow to their whims, forcing concessions within contractual obligations, and that they had to agree to those concessions because this movie was post-production. We had to get it out. There's a lot of money invested, a lot of money to be made, and certainly a lot of money at stake threatening to be lost. That's called an anticipatory breach. And those are concessions that were designed purely to mitigate damages. Because, look, we're going to sue you later, but we're doing this now because if we don't, we're going to lose out on millions of dollars. That's really the heart of their argument. And that's the reason why they're arguing it that way. I don't think that these are tribal issues. Not a chance that that's going to get dismissed. Not a chance. Fails to state a claim for intentional interference with prospective economic advantage. In the absence of an allegation that a specific contract was actually breached, the FAC must satisfy the more stringent requirements for a claim of intentional interference with prospective economic advantage. It does not. To state such a claim, a plaintiff must allege it had a business relationship with a third party. The defendant knew of that relationship and intentionally interfered with it. Reynolds with the agents, Reynolds with the production company. The defendant acted solely out of malice. He had disdain for Baldoni because he was jealous of him for the flirty text between him and his wife, or used dishonest, unfair, or improper means, and the defendant's interference caused injury to the relationship. Misinterpreting public interviews and publications of Justin Baldoni trying to stand up for men's rights, trying to advocate for the evolution of men to become, less than these adolescent things that treat women any such way, forcibly trying to misinterpret that publicly to third parties who had potential business with Baldoni in the future. I think we got enough. If you ask me, I think we got enough. And once again, the sole economic relationship alleged in the FAC is between Wayfarer parties and WME, without specification as to which of the Wayfarer parties had such a relationship. The Wayfarer parties, WME, does not even attempt to allege that Mr. Reynolds acted solely out of malice. as is required to survive a motion to dismiss. But the FAC itself asserts that Mrs. Lively and Mr. Reynolds were motivated at least in part by a desire to seize control over a film production. Taking that allegation as true, as the court must at this stage, whether or not it is true, such a motive, akin to normal economic self-interest, is inconsistent with the sole purpose of inflicting intentional harm and insufficient to state a claim for tortious interference with prospective economic advantage. And they cite a case. There's some merit to that. There's some merit to that. Because if they're doing it to seize control of the film, that's not the same as malicious intentions. That's financial intentions. Malice is going to be difficult to prove. But whether or not it's difficult enough for dismissal, I'm just not so sure. I don't think this is getting dismissed. Nor does the FAC allege that Mr. Reynolds employed any wrongful means to satisfy that element. As a general rule, the defendant conduct must amount to a crime or an independent tort. But there is nothing in the FAC that amounts to an allegation of wrongful means. And most of the FAC alleges that Mr. Reynolds approached an exec at WME and suggested the agency was working with a sexual predator, and at a later date demanded the agent drop Baldoni. But sharp language such as insulting a defendant by calling them a thief and scumbag, again, I disregard that argument. He didn't call him a thief or a scumbag. He called him a sexual predator and then demanded that he gets dropped. That's pretty damning and pretty specific and pretty aptly hits the elements that he just talked about. Pleading the presence of false statements alone is not enough to support. All right. Fails to state a claim for negligent interference. It's kind of the same argument. Fails to state alleged proximate cause. I'm just not going to get into that. If the other ones aren't getting dismissed, then neither of these. The Wayfarer complaint fails to allege conspiracy liability. Well, I just lost my place. Here we go. All right. Having failed to allege any plausible claim based on Mr. Reynolds' conduct, the FAC attempts to hold him liable on a conspiracy theory. That attempt fails. Under both California and New York law, a civil conspiracy theory requires that a plaintiff allege an agreement to participate in an unlawful act or a lawful act in an unlawful means, an overt act performed in furtherance of the scheme. This is really freaking hard to prove. Like, you have to not only figure out what the conspiracy is, but you got to figure out and prove how it works. And then you got to prove that there was an agreement to participate in the scheme. And then you have to demonstrate that for each person that's involved in the conspiracy, how they overtly acted in furtherance of the scheme and that it caused damages as a result of that overt act. It's really hard to prove because conspiracies by their nature are supposed to be secret. Conclusory allegations do not suffice to survive a motion to dismiss. A complaint must contain more than general allegations in support of the conspiracy. Rather, it must allege the specific times, facts, circumstances of the alleged conspiracy. Here, the FAC pleads no specific facts indicating the necessary agreement among any parties, any overt acts done in furtherance of such an agreement, and any damages. Even under the liberal pleading standards of Rule 8, a complaint must do more than assert the defendants agreed to commit a tort. I kind of feel like the judge might tell the Wayfarer parties that they're going to have to amend to ferret this out a little bit more. I feel like they might. They may. I could see it happening. But at the same time, I could just see them, waiting until discovery is done, and then perhaps we'll see. But that is all the FAC can muster. The complaint must provide some factual. All right. Read individually or as a whole. The FAC's allegations that Mr. Reynolds participated in a conspiracy to engage in tortious conduct against any of the Wayfarer plaintiffs are utterly conclusory. They amount to bare assertions. Unsupported speculation and pure boilerplate. They're a little more than boilerplate. appearing to recognize the deficiency, the Wayfarer parties confine each of their allegations of conspiracy to information and belief. That's not because they're trying to confine or they recognize, well, I actually kind of agree. They are aware that they don't have enough to state specific things, and they're very careful to plead on information and belief because conspiracies by their nature are supposed to be secret. And so that usually requires depositions and full batteries of discovery, production of documents, text messages, and all these kinds of things to ferret all those things out. But once they have all of those things, then, you start to see where you're filling in the gaps. But you have to also understand that the pleadings were not verified. That means they're allowed to be sparse to the extent that the causes of action allow. Meaning you're allowed to plead on information and belief because we don't know everything yet. We suspect we don't know everything, but we need to get to the bottom of it. We need to conduct discovery and so forth. So there's some merit to that. That only confirms that the Wayfarer plaintiff's conspiracy allegations fall short because claims made solely on information and belief are insufficient to sustain a conspiracy theory. But not all of the claims were on information and belief. There's nuggets of truth. There's nuggets of it that are based on actual evidence, eyewitness testimony, or what's purported to be eyewitness testimony, text messages, writings. It's not just information and belief. There's stuff there. It's all of the other stuff, the particularized pleadings that are not, that are holes that need to be filled in later. That's the difference. The court should award Mr. Reynolds attorney fees pursuant to New York's anti-SLAPP law. Mr. Reynolds is entitled to attorney fees under the substantive fee shifting provision of New York's anti-SLAPP statute, New York Civil Rights Law 70A1, which applies to the FAC's allegations against Mr. Reynolds for similar reasons to those articulated in the Sloan and New York Times motions to dismiss, both of which Mr. Reynolds joins and incorporate by reference. Section 70A mandates a fee award in Mr. Reynolds' favor because, as discussed above, the First Amendment complaint asserts causes of action against him based on communications and conduct in furtherance of an issue of public interest, namely Mr. Baldoni's and Mr. Heath's harassing workplace conduct and the subsequent retaliation, and cannot survive a motion to dismiss for failure to state a claim. Well, I guess we'll see. Although this court reached a seemingly different conclusion in Brady v. NYP Holdings, Mr. Reynolds respectfully submits that the reasoning of Bobulinski, rather than Brady, should control here for three reasons. First, in Brady, the defendant requested anti-SLAPP fees in a single footnote that did not analyze whether 70A1 applies in federal court. And the court accordingly did not have an opportunity to confront the arguments presented here or discussed in Bobulinski. Motion dismissed at 17 and 6. Brady versus, okay. Brady was decided before the New York cases confirmed that 70A1 makes attorney's fees available not as a sanction, but wherever a SLAPP claim is dismissed for failure to state a claim. As interpreted by the New York court, 70A1 is not a sanction, but an exception to the American rule applicable to a class of cases defined by state law. For that reason, Brady's reasoning that Federal Rule 11 answers the question covered by 70A1 has been overtaken by intervening New York law. Third, and finally, it is well settled that the state fee-shifting statutes are substantive laws that must apply in diversity cases. Just as the presence of Rule 11 would not be an obstacle to a prevailing party fee, I don't think they were arguing that. If they get the thing dismissed for failure to state a claim, they're going to get attorney fees. The court should strike Exhibit A to the Wayfarer complaint or at minimum disregard it. All right? Mr. Reynolds joins the argument in the Sloan motion to dismiss, moving the court to strike the FAC's Exhibit A pursuant to Rule 12F As this court has recognized, permitting a party to satisfy its pleading requirements by attaching documents other than instruments to the complaint would do considerable damage to Rule 8A's notice requirement, including by requiring a defendant to hunt around in voluminous materials to figure out what the plaintiff alleges is relevant and supports its claims and what is extraneous. Even if the court does not strike, Exhibit A cannot properly. All right, whatever. Conclusions and stuff. Conclusion is grants our motion. We've already done the Exhibit A argument before. I don't care to do it again. So that was a mouthful. How do I get off of this? Stop it. Stop it. Stop sharing that screen. There we go. Oh, boy. What's up, Amy Les? She says, what do you say? The Ask Two Lawyers podcast said all that YouTube and book excerpts can't be considered because they are not in the. No, I agree. That's 100% was like my point of my rant. It's like, I don't understand their strategy of going all the way back to stuff that he was talking about when he was a teenager and in his early 20s to litigate issues of this man who was in his 40s, is like 41 now, 40 at the time of filming. I agree with it, and it shouldn't come in. Now, I'd imagine that they're going to raise that in the opposition as well. It's not being alleged anything that he did wrong, you know? And it was, I said that it was particularly disgusting because they're going into stuff that he was speaking on his podcast and, you know, utter humbleness and extolling the virtues of his spiritual growth and admitting certain things of his character. And for them to then go and take that around, he's obviously admitted that he's a sexual predator. He could have, for all I said, for all we knew, been talking about like sleeping with somebody before the third date or something, as an example of they did not define what that even meant. If it even comes in, they haven't defined specifically what they're talking about. They're making extreme logical leaps to conclude that because of that, Ryan Reynolds understood that he was a predator and therefore we got to dismiss. Get the fuck out of here with all of that. It's not, I agree with Ask Two Lawyers to that regard. I haven't watched that show, but I agree with what they said, if that's what they said. Francesca says, Ryan makes much more money than Blake, and this lawsuit is impacting his income. They probably agreed he would throw her under the bus and try to get out from under the suit. Yeah, I agree. I agree with that. I've said many times that there was a financial interest for Lively to pursue Baldoni and smear his name the way that they did. And I think that Baldoni was negatively affected. Now, I don't know what's going to happen if he's successful in this litigation, but there's no chance that it hasn't affected him. You know, I think people are kind of waiting to see how this comes out PR-wise before they decide to put him in a major project again. Anyway, before I go, Isabel says, wait, before I go, Justin talked about how he was planning to wait for marriage to have sex, but his ex-girlfriend basically violated. Yeah, he did say that. He did say that. And then how he felt like, he couldn't really be honest about it because he would get made fun of. He said stuff like that. He has said stuff like that. The Crow says, Ask Two Lawyers needs to spice it up. Well, good luck asking a couple of lawyers to spice anything up. It's, look, man, not everybody's got a family law after dark the way that I do. Not that I spice anything up. I'm just saying. Atsukido with the $50. Thank you so much, man. You're so appreciated. You are the real deal. Love you so much. And I love you too. And I love all of you. And thank you for being up with me for an hour and a half. I know for some of you guys on the East Coast, it's like 2:30 in the morning. It is 11:30 for me. And, not everybody's brain is functioning at 100% right now. So I do appreciate you spending your night with me. Missy, I appreciate you being on my streams in Omar's righteous anger. Righteous, it was certainly anger. I don't know if it was righteous or not, but I appreciate the sentiments 100%. I love all of you, and I will see you guys tomorrow. I'm trying to coordinate a stream about the Idaho 4 case and the Bridge Guy case. There's stuff that's been going on. I've been wanting to talk about it. I just, it's been like the 2 busiest weeks of the year for me, trial-wise, at the old law office this week. And I've been trying to navigate this show and that at the same time. And so, I love you folks. I hope you guys have a wonderful night. I wish you the sweetest of dreams, and we will see you guys tomorrow. Bye-bye.